Good afternoon, everybody.
Hi, Niska. Hello to everyone else.
Good afternoon, everyone. Good afternoon.
Hello.
Hello.
Good afternoon.
Good afternoon.
Hello.
Hello. Okay, I see the majority of persons are on. So we'll get started with Unit 1. Before we begin, by next class, we will provide for you a copy of the Companies Act along with the IBC Act. So you could begin to familiarize yourself with it. You will see at the end of each chapter, there are cases. You can go online for synopsis of those cases, and you'll see cases that are mentioned within the units. We normally don't spend a lot of time reading the cases in class. You can do those as a part of your homework.
Yeah.
I normally try to give a few homework questions just so you can get a feel of what the final exam questions will look like. And you can see what I'm looking for when I mark the exams.
And
So,
would you introduce yourself, ma'am? I don't know who you are.
okay, so I'm the lecturer. My name is Christine Archer. I'm
Wonderful.
Johnson. I'm an attorney by profession, and I am also a compliance professional.
Yeah, Christine Archer, co-host. Okay, right. See it. Wonderful. Thank you.
Okay, so it was my mistake, but some of the students know me. So
Yes, we've been here before.
Right.
Ms. Archer, quick question. Has
Go
the
ahead.
course been shortened? Because for some reason I felt like this was on for a much longer time last year. I'm trying to figure out why it's only 2 months.
Oh, because we've doubled some of the classes.
Oh, okay.
Yeah.
Okay, that
Yeah.
sounds it.
Yeah. Because sometimes okay, so some of you would have had one chapter per class, but over time, based on the classes and the way in which, we run the classes, you can actually put them together.
Okay,
Yeah.
makes sense.
Yeah, it makes sense. So it's shorter, it's quicker, you're more focused, and get it over with rather quickly. All right, so that's the exams. Hold on 1 second. I think he's sending the schedule. Normally we have a midterm, or we can just have one exam at the end, which is a comprehensive exam covering all the chapters. And normally we also have a capstone. So, the capstone is a research-based question. The capstone is due the same time as the final exam. And so my question to you all, you can get back to me next week, is to whether you want a midterm. If you have a midterm, the midterm will cover the first 5 chapters, and which means that the focus for the final exam will be a little bit different. There won't be a lot of concentration on certain chapters. So you can let me know next week what you prefer. One exam covering all the chapters, or a midterm, and then a final exam. But I will give you a capstone question because that's a part of the overall grading.
Okay, Anishka, Happy New Year to everyone.
Happy New Year.
Yes, I have a question, right?
Go ahead.
About the class. What is the success rate of the class?
Success. What do you mean success? Passing.
That's a good question, Aniska.
Because I started your class last year and had to, unfortunately, life slapped me in the face a couple times last year, and I had to pull out of the class. And here I am again, energized to start again. So I need to know. I need to know what is the success rate.
Should I say 85-15?
With 85 being the success and
Yes.
15 being a failure. Okay, that's not too bad.
Okay.
No.
Lolita, we're gonna be in that 85.
We're going to be in that 85.
Yeah.
We're ready this time.
Okay, so let me give you couple hints towards being in that 85. When you have the capstone, which is take home, you will have a lot of persons make this mistake. It's due the day of the final exam. So they decide to write it on the last week. So what does that mean? If you've had the all of this time to prepare it and you prepare it on the last week, you just pull it out, you just answering it. Will it be the same as someone who started from the day the assignment was given?
No,
No.
you're gonna be cramming. You're gonna be cramming.
Yeah, exactly. And so there you're gonna lose points. So if you take your time and you do it properly, it's marked out of 100. You could come up with anywhere from 80 to 95 to 96. But if you do it on the last minute, and I've seen it over and over again, some people end up with 20 points, some get 40 points, some get 30 points. Because they haven't taken their time and looked at the question and answer it properly. So that's the first thing where they lose points. The next thing is that for the final exam, I would always guide you as to what's coming. So you don't be studying all over the place. So the first thing you know is that in any exam, after we've gone through this unit, you have the Companies Act or you have the IBC Act. You can use either one as your reference and answering your questions. You don't need to use both. So if you're answering a question and there is provision in the legislation for it, I expect that you would say that this is what the Companies Act state or this is what the IBC Act state. That's the first thing. The second thing is you're going to see there are case laws. And so where your question refers you to actually putting in a case and you don't put in the case, you're going to lose points in the exam. The third point is that when you answer exam questions, your answer at the end of the day has to show me that you understand the principle. So you can't go to the left, then go to the right, then come to the middle, then go to the left, because it tells me you don't understand it. So as I give the homework, if you want to try to master how to answer the questions in the exam, then I would encourage you to try, write it out and send it in. I find students who actually did it on a constant basis. Every time I threw the question, they would write it, they would email me, and at the end of the exam, they did very well. Okay, I finished that part now. Any more comments? Why everybody's silent now?
No, I don't have any more comments. I'm waiting to get started.
Okay, all right. But Mr. Drico is new, so he'll have some questions before I start. I don't want him to get confused and tell me he didn't know.
No, you covered sufficient that I don't have any questions right now.
Okay, very good. All right, so let's begin with chapter 1. So when we talk about company law, we're talking about an actual person, a legal person. And that concept has to be in your mind as you go through this course. Because you have to realize that once you create a company, that company can act just like an actual human person. So before we get into that part of it, let's start out as to why would they want to create a company? And people do it for different reasons. Some of it is because it's for a particular purpose. Some of it do because they want to invest or they want to give donations. And some of it do it because a lot of them may decide that they want to come together as a group. and form a company in order to reduce their liability. And some people form a company because they want to have investors, not just them and their family, but also persons from the public, so they can get a larger pool of funds in order to grow their business. So we know that a company itself, once it is registered, which means that it has a certificate of incorporation and has met all of the requirements, it then forms a separate legal personality. In any company, there are two organs, and those organs are the board and the shareholders. The shareholders is at the very top, and they are the beneficial owners of the company. And that's where you have the annual general meeting. The annual general meeting, you'll see in later down in the chapters, that's referring to just approving who's going to run the company, looking at who is going to be the auditing firm. Other than that, all of the actual running of the company is done by the directors. And the directors and the CEO are appointed at the AGM. Always remember that a company is not an agent of its shareholders and its agents and its principals. That is paramount for you to understand, because a lot of persons form a company and the shareholders believe that the company is its agent, which means that they can use the funds in the company as they see fit. Why
Trouble.
you laugh?
No, I understand what you're saying. That's trouble.
It is trouble, and it happens every day. A lot of persons form companies and they believe that they can use the funds as they see fit. For example, a person forms a company and then they begin doing let's say the company is what? Making bottles. That's the purpose for the company. So it has employees, it has auditors, it has a board, shareholders. Now, you know, in most companies, when it first starts out, the shareholders like to appoint themselves either in a directorship role, or they try to be more a part of the day-to-day functions. They will get the role just to ensure that they're overseeing what's going on. So you then begin to see that, of course, they are doing business on behalf of the company. There's a lot of promotion to be done to get the business up and running. So what do you think that shareholder slash board of director slash doing some day-to-day work, what do you think they're going to do?
Start paying themselves.
And how do they do that?
Well, if there's a cash register, they may take out a few dollars during the course of the day. Or at the end of the month, they might write a check to themselves and don't record it in the general ledger.
But another way that they do it, if you're dealing with a big company, is they incur legitimate expenses. So let's just say they needed to go and see a client. So they would book that expense. And so they are paid for that. So let's just say they have to travel to see somebody, some client, some arrangement, some company to strike some deal. They will ask the company to pay for that. And you know, most times when you travel on behalf of a company, there is a budget. So it goes beyond the budget because they are a shareholder. So they're not staying in any and every place. They're not using a regular taxi. They're using a limousine service. So they begin to use the funds in the company as if it is their own.
Yeah, I see what you're saying.
Ms. Archer?
Yes.
Hi, good morning. My name is Yvette Ramming. The class. I'm a first-time participant in the class. I am also an attorney.
Okay,
And my specialty is commercial and corporate law. And
okay,
I just wanted you to also expound upon the positives with respect to persons who are working as management within the company, who may also be shareholders, who may be doing these things legitimately so as not to, I guess, paint the picture that all shareholders / management employees are of the mindset that they act
all right.
nefariously with respect to funds that are legitimately capital of the company.
Okay,
So that persons don't form that opinion of every single business shareholder / management, CEO, etc.
okay, all right. So let's take it from the flip side then. If you have a shareholder or member who is also a part of the board or acting on behalf of management, one of the key things they know is that whatever they do has to be within the policy framework of the company. And they also know that there are limits and there are authorizations. So when you act in those positions, you know that that a manager in a certain department has a limit. You know which matters need to go to the board. And when you don't know, then you ask the CEO. If the CEO doesn't know, then the CEO goes to the chairman of the board to find out whether or not a certain action can be done. So there are persons who work within the framework of the company and who follow the natural process of getting the relevant approvals to carry out certain acts. So they are both sides.
Yes.
Okay. So the next, I gave you a case here of DPP, and
Just
that
a question, Ms. Archer. What's the difference between a shareholder and a member?
normally for public companies, you say shareholder. Normally when you're dealing with IBCs, you'll just say a member.
Okay, thank you.
Yeah. So in the case of DPP, it just pointed out that a company is considered an artificial legal person. And in this case, whenever you deal with sexual harassment, you're talking about an actual person, a human person. And this act itself didn't envision that it envisioned the person who brings a suit for harassment is an actual human being and not a legal personality. So whenever you talk about someone going into business, if you look around here in the Bahamas and in most countries around the world, there are three types. It's either a sole proprietorship, a partnership, or it's a company. And you can see that a lot of sole proprietorship over time have actually, after death, it just dies. And that's the reason, that's one of the main disadvantages of having a sole proprietorship. So if you look at the three forms of which you can go into business, there are advantages and there are disadvantages. So a sole proprietorship does not have a separate legal personality. A sole proprietor controls everything in his business. He has all the responsibility and he has all the liability. So it's his own private business. He doesn't have to register. He doesn't have to prepare any financials, even though he should. But the drawdown to all of that is that he is legally liable for all of the risk in his business. Now, a partnership is not a corporate entity. And of course, it's governed by the Partnership Act. A partnership is dissolved when the partners retire or they die or goes bankrupt. Now, partners, again, the remaining partners, if one of them dies or they retire, the remaining partners are subject to the partnership agreement, and the retiring partner is paid out his entitlement. If the partner deceased, then of course his executor or executress then of course will seek to get their relevant share from out of the partnership. Now, the legal and the financial liabilities of the partnership extend beyond the partnership to the individual partners and to their personal assets. Again, the business affairs of a partnership are private, and there's no obligation to register financials. But then again, it depends on what services that partnership is offering. Because once a partnership offers a service that is regulated, then of course there are other requirements. Creditors can sue partners individually to satisfy any obligation of the partnership. And remember that partners are also liable for the actions of other partners or actions that are done on behalf of the partnership or in the partnership name. So in most instances, this option is always to form a company. A company has perpetual succession, which that its existence goes on and on as long as it meets its regulatory and statutory requirements. You can take a company and you can sell the company to another person, to a new shareholder. If the shareholders die, the company continues. If the shareholder retires, the company continues, because what you have is a transference of shares. Any questions so far? No questions?
What would be a reason for creating a partnership if it seems to be more negative than anything to me over a company?
Well, it depends on the parties. Most parties, instead of, let's just say if you open an accounting firm, you may start out by yourself as just a sole proprietor, just you one. But let's say 2 or 3 other persons come together. They may decide that they want a partnership, something that's very simple. Remember now, once you form a company, you now have statutory requirements and regulatory requirements.
Yeah.
Mm-hmm. Okay.
There's more administrative work to be done. Some people don't want that headache because it is a lot.
Okay. Noted.
Okay. So a retiring shareholder has to find a buyer for his shares. And of course, a trustee in bankruptcy or a trustee that might also find a buyer for the shares.
Can I ask you one question about a partnership?
Go ahead.
Can you take out an insurance policy that would cover dishonest acts by your partners?
Yes, you can get liability insurance.
Yeah. Okay.
Mm-hmm.
Specifically for defalcation, whatever trouble that somebody else might get you in. So it's not really, you do mitigate risk by doing that, don't you?
Yes, yes.
Okay.
Ms. Archer?
Go ahead, Yvette.
I think a good example of, I think that's Mr. Trico's point about indemnity. I think most accounting firms and legal firms do have to, by nature of the profession, take out indemnity insurance for its individual partners. And that serves as a risk mitigator for those types of entities.
But in most companies that operate a business, they do have indemnity insurance.
I'm talking about the professional indemnity for those bad acts. Right.
Yeah. No, what I was gonna say, in most companies, like large companies, when they purchase insurance, it includes professional insurance and other indemnities, and you really have to read the fine print. Because it's when you look at it, sometimes it doesn't cover a lot of acts that are actually carried out by individuals.
Yeah.
So that's the thing
I have
about
a
it.
question.
Go ahead.
This is Charmaine. This is my first time as well. So if you're able to get a liability insurance, would the creditors or any creditors that are coming against you, would they still come against your wealth, or does the liability insurance cover you?
No, that's the point I was making. The insurance does not cover 100%. No, it doesn't work like that.
Okay.
It would usually cover a ceiling, a Christine.
Yes, it has a ceiling.
Yeah, okay.
Yeah, it has a ceiling. But but the thing about it is that normally when you purchase insurance, you purchase your insurance from one broker. And so it's all of the different types of insurance that you want one time. So there's a gradation of the ceilings, because remember now, insurances are in this to make money. And so there is no all blanket coverage. Everything is done based on ceilings, and there's restrictions and there are limitations.
Yeah, the insurance company may not cover the first $1 million worth of liability.
Exactly. Yeah.
That's it.
Yeah. So and depends on what the incident is, then they will tell you what's inclusive and what's exclusive, what's permitted, what's not permitted, and depends on your role in the organization, whether or not it's inclusive in that provision. So yes, there is insurance to mitigate against the risk, but I always tell persons who are becoming directors, that's the first thing they need to do, is to read the insurance coverage, see what you're covered for before you begin to act.
Yeah.
So in a company, of course, you contribute payment of a company's debts to a limited extent. That's one of the beauties of forming a company. While a shareholder is liable to contribute to the payment of a company's debts, he's not liable to pay them himself. So a creditor cannot sue him nor compel him to pay any part of the debt, because his debt is only equal to the amount of the unpaid capital in respect of his shares. Now, a corporation can be sole or it can be aggregate. A sole refers to where the company exists of only one member at a time holding a perpetual office. And that, for example, could be someone like a public trustee. A corporation aggregate is more than one person who in law form a single person, and that's a registered company. And like I said before, a company can be incorporated either under the Companies Act or under the IBC Act. So when you talk about a company, the whole concept of a company having a separate legal personality came from the case of Solomon versus Solomon. And in that case, because I know you've read it, everybody has their book, they would have talked about how he was a sole proprietor and then he incorporated a company. And then when the company went into trouble, the creditors decided that they were going to sue. And what they were trying to say is that he and the company were one and the same. And the judge came to the decision that they were not. He said that once he received that certificate of incorporation, which means that he met all of the statutory requirements for establishing a company, that it was a separate and legal entity. They were not one and the same. And that case is the founding case of a separate legal personality. That is what a company is. It's not one and the same. Also in the case of Macora versus Northern Assurance, and this was again about a sole proprietorship, forming a company, and of course there was a fire with the timber. Who really owned it? So he did an insurance policy, but he did it in his own name. He didn't do it in the name of the company. And he didn't do it either as an agent of the company. And so at the end of it, was he able to claim? Because he claimed. And they said that he did not have an insurable interest. He could only be insuring either as a creditor or as a shareholder. And in the next case of Lee versus Lee's Air Farming, and this is one where Mrs. Lee's husband, he worked for Lee's Air Farming, his own company. So he was the shareholder, but he was also an employee. And he was killed while piloting the aircraft during one of his spraying jobs. And the company didn't want to pay him for his services. But what the court found out was that he was actually being paid wages, which qualified him as being an employee. And the company kept wages books in which his wages were recorded. And the work that was being done at the request of farmers whose contractual rights and obligations were with the company and the company alone. So he was discharging his duties when he was killed. And the court said that it was impossible to resist the conclusion that the active aerial operations were performed because the deceased was in some contractual relationship with the company. And that relationship came about because the deceased, Mr. Lee, as one legal person, was willing to work for and to make a contract with the company, which was another legal entity. And so a contractual relationship could only exist on the basis that there was a consensus between the parties. And then the court held that his wife was entitled to compensation because the husband was employed by the company in the sense required by the act and the decision in Solomon versus Solomon. So even though he was the shareholder of the company, he was actually carrying out a job as an employee and he was being paid wages. So as a consequence of Solomon versus Solomon, a company has perpetual existence. It continues in existence until it is formally liquidated or wound up, voluntarily or involuntarily by the creditors or the court. So this means that the company, go ahead.
A question, Mrs. Archer, with regards to the Lee incident you just spoke about, would he have been, would his wife have been compensated for him as an employee as well as a shareholder in two different capacities? I'm just wondering.
No, but this matter was as an employee.
No, I understand that. I'm just wondering, Wondering
Well,
if she may
don't
have had
forget,
double claim and that was the
but he
reason
owned,
why
he
they were
owned,
having an issue.
yeah, but he owned the majority of the shares. So that part of the shares, it depends on who, on the memo and odds as to what happens upon his death.
Yeah, yeah.
Because his executor then would have to
When the
carry out it.
beneficiaries
Yeah.
would be.
That would fall into his estate.
Yes.
Mhm. Yeah, so the claim that she was, what I gather is his wife was claiming under the Workers' Compensation Act, and to say that he was an employee of
Exactly.
of the air company. So it's just like if you, I think it's just like with national insurance.
Yes.
If he's working and he gets injured on the job, and he's been paying national insurance premiums and all that, the person can claim under the National Insurance Act as an employer.
Right.
As an employee.
Right. And so
Right.
that was the argument here as to whether or not he was an employee, bearing in mind that he was also a shareholder.
Right.
Yes. So when you talk about the Solomon principle, and you see now how that principle works, there are two exceptions. One is where there is an agency relationship between the company and the shareholders. And the second one is where, based on the corporate structure, it is what you call that is just a mere facade. And that's when the court will actually disregard that separate legal personality and go behind that and reach the shareholders, or what we call pierce the corporate veil. So a parent company is a company which owns sufficient shares in a subsidiary. To determine who should be its directors and how its affairs should be conducted. So, you know, we have a lot of subsidiaries here. So when you have a subsidiary, normally the person who sits as the CEO or who sits as chairman of the board is selected by the parent company. The parent company is merely the large shareholder of the subsidiary. So when you look at the ownership structure of a subsidiary, you see that the parent company owns 99% of the shares. In some instances, 100%. So where the legal personality of a company is separate from its shareholders, so is a parent company legal personality separate from its subsidiary. So even though the parent company owns the majority of shares of the subsidiary, they are still separate legal entities. A parent company cannot sue to enforce the rights that belong to the subsidiary. Nor is the parent company liable for its subsidiaries' breaches of contract or tort, because they are two separate entities. But an agency relationship can arise in the context of group companies, where the company will plead, the parent company will plead that a subsidiary company is its agent. And you'll see now with a lot of the beneficial ownership requirements that a lot, well, under the banks and trust companies regulation and supervision, they have always asked for group structure, because the group structure then determines whether or not the company itself, based upon its actions, is acting on its own, or its will and directing mind is coming from its parent. So in the case of Smith, Stone and Knight versus Birmingham, the issue at hand was the compensation for compulsory purchase by a local authority when the property of a subsidiary company was acquired. And the judge stated that an agency relationship was a question of fact. And he identified certain factors that would assist in determining whether there is actually an agency relationship. And he says one thing is, who was really carrying out the business? who received the profits, who was actually conducting the business, who appointed those persons, who was the head and brains of the venture, and who was in effective and constant control of the business. And you would see that the G8 and the G10 countries are now moving towards that same direction when they're talking about companies that have operations overseas as to who is actually the mind of that company, how much of those profits are actually being sent to the parent company, and who is doing all of the appointments and who's actually controlling that company. So the court held that in this case, that the arrangement between the parent and the subsidiary was that the business and the profit belonged as a matter of law to the parent company. The subsidiary did not operate on its own, and the parent company was the party entitled to claim compensation. And so you'd see when you have regulated entities, there's only a certain amount of profit can be repatriated back to the parent. And that's to try to keep them as separate legal entities. So in on all circumstances, the Solomon principle is always applied to a registered company. But there are other cases that I've listed here. Then you could read some more on the agency relationship. So that's one of the exceptions to the Solomon principle. The second one is lifting or piercing the corporate veil. And this refers to, like I said earlier, to the court looking behind that separate personality. Because you know that Solomon versus Solomon established that once you've moved and you've established a company, you have your certificate of incorporation, the shareholders and the company are separate. So piercing the veil has been used indiscriminately by the courts. And that was some of the comment that was made in the case of Press versus Perpetual. And we're going to discuss that next week before we begin Unit 2. So I give you time to go on the internet and you can pull it down and read it in its entirety, because it actually goes through some of the leading cases, the old cases that were decided on piercing the corporate veil. And what the court is saying is that there are other ways to come to a resolution rather than disturbing that separate legal personality. They're saying is that based on the Solomon principle, we should stand behind that concept that once you form a company, it is a separate legal entity, and find a different route to try to come to a solution to whatever the problem is that the company is trying to resolve. So in piercing the veil, they say is reserved for instances where the court does indeed ignore the separate personality of the company and looks behind the corporate veil to the members. And the courts use their discretion to pierce the corporate veil. That is, ignore the Solomon principle when justified on public grounds. So in the case of Press versus Perpetual, the court unanimously agreed that the doctrine exists. However, they're saying the judgment suggests that there is not a single illustration of its necessary application, and that principle should only be relied on where it is necessary. So when you read some of the cases at the end of the chapter, because we'll go through some of those when you've had the time to read them this week, you will see that when you read Press versus Perpetual, it tells you that there are a lot of instances where the court could have used other solutions rather than piercing the corporate veil, meaning going behind the separate legal personality and suing the shareholders themselves. So in earlier cases, the courts found that the corporate structure that is created by the shareholders of a company is a mere facade. That means that the company was created to conceal the true origin and ownership and the operation of the business. And in that instance, they would actually discard the Solomon principle. And they would go behind it and touch the shareholders. and make the company and the shareholders as one, and impose the liabilities on the shareholders and the company. So I give you the case of Wolves versus Strathclyde. And in that case, there were several parties. You had Solomon Wolfson, you had Soulfield Holdings, and you had Campbell's Limited. Now, this case again concerned compensation, payable again on a compulsory acquisition of land by a local authority. So the land was owned by W&S Limited, 2030, and the shares were issued in Salford Holdings and Solomon Wolfson. 10% was held by his wife. So the land was occupied by Campbell Limited, and Campbell Limited carried on his business from this actual space. So the shares in Campbell Limited were held 99.9 by Wolfson and 1 by his wife. So Wolfson argued that he and Campbell Limited and Salford Holdings should all be treated as a single entity, meaning that he is the key to all of this, and they should be regarded as embodied by himself, who should be regarded as the owner and occupier of the land for compensation purposes. But the court rejected his application to pierce the corporate veil, as this could only be done in special circumstances where the company was concealing the true facts. The court found that there was no ground for treating the company as a mere facade, so that Wolfson might claim to be treated as the owner and occupier of the land. Campbell Limited, which carried on its business from the premises, was to be compulsory acquired, had no control over the owners of the land, who were Sulfreed Holdings and Wolfson. Wolfson held only 2/3 of the shares in Sulfred Holdings, while Sulfred Holdings had no interest in Campbell Limited. So therefore, Wolfson could not be treated as the sole owner of Campbell Limited, as the one share was held by his wife, was in a nominee capacity. So therefore, the corporate veil could not be pierced to the effect that Wolfson was the true owner of the business of Campbell Limited, or the assets of Sulfur's holding. Campbell Limited, as the occupier of the land and owner of the business unit, was responsible for any direct loss as a result of the compulsory purchase. So the courts will also lift the corporate veil where, in their determination, the corporate form is being used as a sham or facade to evade the company's existing liabilities or to defeat the law. So lifting the corporate veil is a concept in company law where the rights and duties of a company, which are in principle the responsibilities of the company, become the rights and duties of the shareholders of a company in a limited number of circumstances. And those circumstances have been defined by the court. Particularly in situations where a company is insolvent and unpaid creditors wish to recover their monies from persons involved in the company. So the courts have pierced the corporate veil and determined that, one, the company was a single economic unit, and that was Adams versus Cape. They pierced the corporate veil and established that it was an agency. That was the Smithstone versus Birmingham. The evasions of limitation imposed on conduct of law, and that's Guilford Motor Company and Jones versus Lipman. And evasion of the right of relief of third parties in Re-A Company or Trustor versus Smallbone. So when you read the case of Press versus Petrodel, you will see where the courts decided not to pierce the corporate veil. They have actually said that there are other grounds upon which you can come to a solution instead of piercing the corporate veil. So be mindful that third parties can only sue the directors when one of the agency or trust or arguments can be advanced. It's difficult for third parties to sue the company's directors for liabilities of the company's unfulfilled obligations. Third parties has to sue the company. Directors' liability is not limited as the members. Directors have a duty of care to the company, and the company can sue the directors for any wrongs that they have committed against the company. Any funds that you recover belongs to the company. Directors' liability for corporate losses is not strict. Directors do not guarantee that the company will be a success, but it is a liability for wrongs committed against the company, such as negligence or breach of duty to the company. You have any questions on piercing the corporate veil? If you look at the end of the chapter, my pages are numbered at the end of unit 1. You're going to see 53 cases.
Yeah.
Now, some of these refer to the Solomon principle, and some of these refer to the exceptions to the Solomon principle. That is various examples of piercing the corporate veil, when the court would have pierced the corporate veil and the grounds upon which they did it. So for next class, I need you to begin to read these. You can decide whether you're going to do, should we go down and just assign them? The ones that I mentioned in the book, we could skip. Number 1, we don't have to do that. Number 2, number 3, number 4. Who wants to do Adams versus Kate?
I could do that.
Okay, all right. Who wants to do Daimler? Number 9.
I'll do that one.
Who is that?
Sherelle. Sans.
Okay, Sans. Okay. DHN Foods.
I'll do that one.
Okay, that's Jolene.
Yes, Jolene.
Jolene, okay. LSU versus Dollar, number 14. I'm trying to pick the ones that you can find easily.
Hmm.
I can do that. Is he back?
These will come up if you Google them. That's what you say?
Yes, yeah.
Oh, okay. All right.
I'll do
Guilford,
LSU.
okay. Guilford Motor and Jones and Lipman, 17 and 18. They're very easy to find.
Charmaine, I'll do that.
Okay.
That's 2.
Yeah, that's 2. There's you'll find them already in summary form. So you could discuss those in class. Who wants to do MCA record versus, well, I have that already in the book, so you don't need that one. What about multinational gas, number 27?
I'll
I
take
can
that.
do that as well. Okay.
Who? That's Yvette?
No, I was doubling up. So if someone wants to have that, they can have that as well. I mean, can have that.
Okay. Someone wants that one?
Yeah, I'll take that one. It's Kristen.
Mhm.
Okay, Kristen. Polypack?
I'll take
I'll
that
do
one,
that.
Anishka.
Oh,
sorry,
darn.
Lo, you slow to draw.
Listen here, that have such a catchy name.
Oh, Lord. I'm trying to see how many more. Let someone do number 24, Meridian
40.
Global.
What about 40? I don't recall that one from last time.
40, yeah. You want to do 40?
Yeah, I'll do 40.
Okay.
Low leader.
Yeah, I got you. Someone could 24, Meridian Global Funds.
Yeah, I'll do that.
Okay.
Mr. Trico or Trico.
Yeah, I have you. Yeah, I put you down. This one, I have this in the notes, but someone should read this one. Number 42, Standard Chartered Bank versus Pakistan. That's a good one.
Yeah, that's fraud, isn't it? Yeah.
Mm-hmm. Who wants to take that?
Yeah, that's interesting because the director acted outside his duties.
Mm-hmm.
So the company couldn't be held liable
Yeah,
directly.
that was a good one. Okay, so no volunteers for that. All right. What about 48?
Ms. Arch, I can do 48 Mills.
Okay, all right. Who's gonna do 51?
That's an important one, man.
Of course it is. Everybody has to read 51, but someone has to present it. Who haven't I heard from? Sans, what about you? Sharia.
51?
Yeah,
Okay, that's fine.
okay. So you'll present, but everybody has to read 51.
Okay.
Okay.
Okay, what else? I think that's it.
I have a question.
Go ahead.
The cases they're provided separately in the emails.
Not at the back of the book,
Oh, they're at the back. Okay, thank you.
back of the unit. They're at the back. So we'll try to provide for you for next class, the legislation. And then we'll go over the case. So now let's start corporate liability. So being mindful that a company is a separate legal entity, it has its own personality. So of course, it will have corporate liabilities. So that means that it can enter in a contractual relationship with other companies or with persons. And of course, it can incur liability. So if it decides to enter into a contract, anyone who wishes to enforce the contract that they enter into a company have to ensure that the company itself has the capacity to enter into that arrangement. And the second thing is that the person who is acting on behalf of the company has the authority to actually bind that company in that act. So you will see there sometimes there are instances where a shareholder, because it is his company and he is out there soliciting business, a shareholder will actually enter into a contract on behalf of the company. And what is wrong with that?
Well, the shareholders assuming the personality or identity of the company.
Exactly.
Yeah, but Christian, how would the person who is contracting with the shareholder know not, you know, that he doesn't have the authority to do that?
Okay, because this is the one sign. Whenever you're entering into any contract with a company, the first thing after the person has introduced themselves and you're in the negotiation, the first thing is you need to find out if that person has the authority to do it. And in order to do that, you need to speak with who at the company. You have to speak with who's the managing director, the CEO of the company.
You mean the people who are never, you're not, never able to find?
Because we're all getting on a positive note now.
That's a good one.
Right.
I was gonna say the secretary.
You could ask the corporate secretary, yes.
Yeah.
Not the secretary, the corporate secretary.
I see. Okay.
Yeah.
Right.
All right.
Not the one that's answering the phone. Not that
No,
one.
no, no. I don't. No, I mean the one that it's part of the officers. Yeah.
Yes, the corporate secretary.
Yeah.
But that's key when you entering into a contract. You have to know the person whom you are engaging in this arrangement with, that they actually have the capacity to do it.
Ms. Archer,
Yeah.
are you able to speak to ostensible authority?
Mm, yeah.
Where the individual facing the world may have the authority assumed because of their position. So I may get into a contract with an individual who is a manager at the company, and the assumption is that in the face of there being no notice of whether or not he can or cannot enter into a contract with me, one can apply the principle of ostensible authority, which means that if he appears to have the ability to enter into the contract, then I would not be prevented from calling upon the company to perform the contract. And I think that's an outlier situation where I guess the courts are anxious to assist a third party who would not have had proper notice of whether or not another person is capable of binding the entity. So I just wondered if you can address that in the surrounding the topic area we're discussing.
Yeah, but I understand how it can happen, go before the courts. But I could see it in the past, but I can't see that being done now. And why I say that? Because as a part of doing business today, you don't just assume or say because a person represents a certain company that have the authority to do so. Because a lot of people walk around saying that they have the authority to do certain things, they don't have it. And I don't see where a businessman would want to take such risks, because most people try to avoid going to court.
I
Yeah,
guess
but
that's where due diligence comes in, a
Exactly.
Christian.
Yes.
but Ms. Archer, if you're dealing with the general manager or the managing director of a company, you would expect that he or
Yes.
she has it. I mean, if it turns out that only the chairman of the board could sign contracts, you know, that's
Something is wrong with that company from a governance perspective.
yes.
That's not
Yeah.
normal. No.
Yeah, but I mean, I think it also has to do with the nature of the transaction. If it's in the normal course of business, then you would expect a managing director to have the authority. But if you're dealing with somebody that has to do, I don't know, with negotiation of a mortgage or something like that, you would expect that the managing director may not have the authority to enter into that contract, and you need to deal with an officer of the company, i.e. president, treasurer, or secretary.
Yeah, it depends on the model.
Yeah.
And sometimes
Right.
even though the managing director can negotiate it, the matter may have to go to the board.
Yes, for approval. Yes, yes.
Yes.
Yeah.
So he cannot give an right approval.
Right, right.
So
Yeah,
that
that's true.
principle though, yeah, that principle is intended to assist an innocent third party, but as well to assist the business in the event there is, because when you have a person who sits in a position who is able to negotiate and is able to come to terms, there need not always be a situation where they have the authority embedded in a resolution or in the articles, but by sheer nature of his position and his the work that he needs to carry out, there is the ostensible authority imbued in that person.
Yeah, I see.
So it's a principle
Yeah.
that exists and that works, but it can be abused or it can create
Yes.
issues.
Yeah, agree. One of the things that you can find a lot of English cases, but I always try to find local cases, and sometimes it's very difficult because I find that the local cases, people are able to understand it more, but when you get a lot of these other cases from other jurisdictions that are really complex when it comes to company law, it's kind of like difficult to actually explain what is happening and why the courts decided the way that they did.
Yeah.
Yeah. So a company too can sue and tort, or can be sued. And that was the case of Lloyd versus Grace. And all torts committed by a company is done through agents, directors, and employees. And a company is liable for the acts of its agents if they are acting in the course of their employment or within the scope of their authority. We didn't assign anyone the case of Lloyd versus Grace. I don't think so. Number 21. Who wants to take 21? Who's volunteering? Let's see. Deshaun? I put Deshaun there.
Hello, this is Deshaun. I guess I can take it. This is actually my first time doing this class, so I wanted to just sit and see what happens.
Don't listen to these people, but they were here before. Don't mind them.
Yes. Okay. I guess I'll.
Yes, there's a reason why we're back. We're not experts.
Don't listen to them. Do not listen to them. That had nothing to do with the course.
Understood.
Okay, so they could also have liability as a joint tortfeasor with the company. So a director may be liable with the company as a joint tortfeasor where he is authorized or directed or procured the wrongful act. So if a director is carrying out the duties entrusted to him by the company under the memo and arts, and the circumstances for holding him liable as a joint tortfeasor would be infrequent. And that's the case of MCA records. We assigned that to someone already, correct? No, we did not.
No.
Who wants to do MCA records? Number 22.
I could do it.
Okay. And then I'll see what Bahamian cases I can find, if any. And then, of course, liability of a director for tort committed by him. And that's the one, number 42, Standard Charter. Remember the one Trico what you was talking about? That's a very good case.
Well, I can't, I don't want to do that too.
No, not you. Someone else can do that. Kadrin, you want to do that one?
I have another question, if possible.
Go ahead.
I wanted to know, so when we presenting these are to be presented at next class, right?
Yes.
What are you expecting from the presentation?
Just a summary of the facts and what the court held.
You say a summary of the facts and what the court
held.
Okay. All right. Do we also have to put any of our I guess
comments?
Yeah.
Yeah, you put your comments. And then what I normally suggest is that at the end of the class, if you type your little thing up, one of you can actually put it together in one sheet. So everybody has a summary of all of the cases that we went through.
Oh, okay.
And it'll be helpful then in terms of when you're studying for.
Is there a particular place where we could find the cases from, like search it or?
Just research it.
Okay.
Find it, then you can send me an email.
Okay.
Yeah. That's not
on most of them. You just Google and you were able to find most of them.
Right. And then try to find the one that gives you the most information in terms of summary. Because some of them only give you like 2 sentences, then you might find one that gives you a little bit more. And then what they normally do is give you some references where the case is being applied in other cases. And then it provides more clarity.
Yeah, you can even find videos on some of them on YouTube. So you'll be able to find quite a bit of stuff.
So even if you wanted to, for your presentation, to share video, you can send it around to everybody so they can see it. So when you say my presentation was sent around already on the video, but let me just highlight, because sometimes it's quite helpful.
Okay, well, thank you so much.
Yeah. All right, so criminal law, a company is also subject to criminal law. And we know that happens when the company is found to be vicariously liable. You see everybody ride around with those company vehicles will say, if you see this car being driven in a whatever manner to contact so and so and so. So this happens when someone is driving a vehicle during the course of their employment. And there are instances where the company can be found to be vicariously liable for the act of its employees, especially when they act outside of what they should be doing. Did someone get Meridian Global? What number was that one? Yes, Trico, you have Meridian Global.
I do?
As LGU. Yes, Yvette has that one.
What I got myself into?
What you mean? You're excited. You're excited about doing this.
You can see it.
Yes, I can.
Okay.
Excuse me, Ms. Archer.
Go ahead.
What was the other one you gave me? Was it 42? I know 48 was one.
42. You got 42 and 48.
48. Okay, thank you.
But everybody has to read 48. And so some of the other
51, eh? You said everyone had to read
51,
51.
Yeah, 51. And so what I will do is some of the other ones that we didn't select, I'll just pick a few of them that are outside of these. And so I will do my presentations also. So that will help. So if I were to go from one, if we start with Trico first and go down the line, since he's first on my phone. Summarize what is meant by a separate legal entity. What does that mean? Ask you to turn the pages. Come on, what does it mean? A separate legal entity. If you want to pass, you can pass and join in later. After you is Deshaun.
Oh, you talking to me?
Yes.
You're on the self-assessment questions. Sorry,
No,
I didn't. Huh?
I didn't. I just out of my
Yeah.
head.
Oh, I see. Oh, sorry. What is a separate legal entity?
Yes.
Well, as we've been discussing earlier on in this lecture, a company limited by shares or by guarantee is considered a separate legal entity. It has its own personality as opposed to a person who may be operating as a sole proprietorship or in a partnership. In a separate legal entity, I think I'll stop there. That's sufficient. I don't want to ramble on and on. I started to ramble.
Okay. All right, Deshaun. What is separate legal personality? What does that mean to you?
Separate legal entity means that it is separate and apart from myself as an individual. So if I have a company, which is a separate legal entity from myself, I wouldn't be liable for all of the debt or risk or whatever may come against that company.
Mm-hmm. Okay. So I'm going to go down to Jolene, correct?
Hi, Jolene.
Jolene. And I keep saying it the wrong way. What are the advantages of
Jolene?
Jolene? Yeah. What are the advantages of being a sole proprietor?
Of being a sole proprietor, I guess that means the assets that held with the company would belong to you and not just the company and its shareholders.
Yeah, there won't be any company. So you own the asset. What else?
Yeah, well, everything would be under you.
Okay, so you have full control over the business. What else?
You have full control. Your business affairs can be private.
Yeah. Mm-hmm.
Not required to register any financial or corporate information at the public registry.
Mm-hmm.
There's more?
Yeah. You're gonna make this now more practical. So
Yeah.
you have more control. You have full control of business, right?
Yeah.
You don't have to share any profits that you make. It's all yours.
Yeah.
You don't have any regulatory filing. You don't have to do any of that. There's no legislation you have to follow, except of course you have to pay your VAT.
Yeah, you don't have to appoint people.
No, none of that.
Yeah.
You could start up at any cost you want to. There's no minimum requirement.
Yep.
But there are disadvantages. So let me go.
That would be like when your sole proprietorship ends, like say if you die or anything like that, then it just discontinues, right?
Yes. And what else? One more disadvantage.
Oh, if something does happen with the business, it would all fall on you. You can't say, oh, that's the business problem.
Exactly. You become liable for all losses and all damages that occurred. Okay. Ferguson, you up next. What are the advantages for forming a partnership.
Hi.
Hi, Aniska.
No, that's fine. Sorry. Can I ask a quick question?
Oh, go ahead, go ahead.
Wanted to know, so you said there's no minimum requirement for a sole proprietorship. So for a company, is there an amount you must start with?
Yeah, to incorporate a company, there's a capital requirement. And then there's the operating requirement for a company, depends on the type of business. But if you do, let's just say if I wanted to start selling bottles, and I sole proprietorship, that I could start with $50, I could start with 100.
Right.
Right. But you form a company, different. It has to be structured.
Okay.
Yeah. Okay, partnership. Who's next?
Okay, I think you were asking me.
Yeah.
Okay. The legal and financial liabilities of the partnership extend beyond the partnership to the individual partners and their personal assets. They can also draw up their own partnership agreement to their liking. And if a partnership is dissolved, can be dissolved when a partner retires, dies, or goes bankrupt.
Okay.
And it, oh yeah, that's it so far. Okay, any other question?
The disadvantages.
Okay, there's no obligation to register the financial or corporate information at the public registry, and it's private.
Okay.
The main advantage of an incorporated company versus these, basically, like I say, the partnership dissolves once a partner dies.
Yeah, it depends on how the partnership agreement is worded.
But yeah.
So partnerships have a limited life.
The partnership are liable for the actions of other partners.
Right? So they have unlimited liability.
Yeah.
Okay.
The good thing is no, sorry, that's it.
You sure?
I was gonna say something else.
You forgot? Can't remember?
No. No, but I'm trying to read as I go along.
Oh, okay. Let me see. Next on my list is catering. What is the principle of Solomon?
The principle of Solomon is on incorporation, a company becomes a separate legal entity, separate, distinct from its members or shareholders, and is not an agent of its shareholders.
Very good. Boy, I tell you, you're all smart. I'm almost ready to write the final exam. What do you think? All right, No? Let's move on to Kristen. Kristen, what was the principle established in Lee versus Lee Air Farming?
Okay, so in Lee versus Lee Air, this is the one where they established that even though he was a shareholder, he was still an employee. So his wife was able to claim that he was still an employee because they had records where he received wages and he was working in a capacity at the time of his death as an employee?
But tie into that the Solomon principle.
Oh, right. So with the Solomon principle tying into that, they were just trying to show that even though he was a shareholder of the company was still a separate entity from him himself as the individual, as the employer, as the employee, sorry.
Okay. So you can't leave out certain things. Certain things are very, very important in terms of tying into the Solomon principle when you give an answer. Who's next? Newbold. When will the courts pierce the corporate veil? Newbold.
Yes, I'm trying to find it.
That's a very good answer. Trying to find it. Okay, we will wait for you while you try to find it.
Okay, I have the corporate veil is pierced when it's reserved for instances where the court does indeed ignore the separate personality of the company and looks behind the corporate veil to the members. It uses their discretion to pierce the veil, that is, to ignore the Solomon principle when justified on public grounds when necessary.
Okay, so you read that. What does that mean?
That there are only certain instances where the court will definitely go behind the corporate veil or look through it in order to find out who the shareholders or members are.
And you gave these those instances, right?
Yes.
Yes, you did. Okay. So last but not least is Yvette. Yvette, you know I have to give you a good question, right?
Don't make it hard. Don't make it hard.
Why?
Give me an easy one.
Everybody's question was very easy, so don't talk about it being hard.
Everybody, they had tough questions.
That is not true.
Thank you, Yvette.
I don't have the benefit of a textbook, so I'm going on everything you said today.
Oh Lord, let me see what the question. How do you distinguish between a company and its members?
Okay. Distinguishing between a company and its members. So obviously, I guess my starting point would be that a company is a separate individual from its members. The members own shares in the company. And the company is, again, its own personal personality. And in terms of distinguishing, and you're talking about distinguishing from someone looking inward at the company? I really don't know how to address that question, but I only can say that they are separate entities, separate and apart. Shareholders and members, used interchangeably, are separate and apart from the company, insofar that the shareholders own shares in the company.
Right.
I will say that shareholders are one of the organs of the company, as you would have pointed out. In general meeting, they are able to make decisions with respect to the company. The company can, on its own, enter into contracts without the shareholders or in most instances their approval, with the exception of those few that are contracts that would be spoken to in general meeting, like appointing auditors and directors, and that's not a contract. But generally speaking, there's just the separation in the fact that they are totally two existing beings, a shareholder and a company. I'm not sure that addresses everything you would wish, but
okay, so if I was marking your question, if I was marking your answer out of 20, I would have given you 14.
okay.
And let me see who wants to tell me what's missing.
Okay.
Distinguishing between a company and its members. Anybody? While Yvette is thinking.
Can we address profit then? The benefit of a profit?
No,
the members receive dividend, in most cases, if there is a profit.
We talked about it today.
Okay. You don't want to go there? You're talking about everything we did today. Okay.
Yeah.
I think that's it for me then. Someone else would have to add to it.
I would say the members are natural persons and the company is a legal structure.
But that ain't what I'm looking for. No, come on. You all know, you know. Come on.
Can you repeat the question, please?
How do you distinguish a company and its members? That gave us practically the majority of it, except one part she left out.
Separate legal entities.
That ain't it. That ain't the part she left out.
Ms. Archer, what about whereas a member may pass away deceased, the company still remains? I don't know if you've covered that.
I mean, perpetual succession.
Yeah.
No, she left out, but that's a little. You would have put that in.
That's a good one.
Yeah. What else? We've been talking about it for the last 20 minutes.
The fact that they have regulatory and statutory requirements for a company and a member doesn't?
No, that's not it.
No.
And come on, you all know this.
Is it because the company is distinct from its shareholders?
She said
It's a
that.
legal entity? I
She
don't
said,
know that.
and that should actually be the clue now for you all to tell me what she missed. Come on, Yvette, you know this.
The only thing I'm thinking about that I may not have explicitly said is that a company comes into existence by way of registering with the registrar of companies.
No, that ain't it.
And that's a nominal one. I think you should give us the goods.
I think so.
I think we all vote. You need to give us the goods.
When I say all this, then you all gonna say, oh yeah, okay, all right. When you talk about distinguishing between the company and its members, one of the key things you have to discuss is piercing the corporate veil. When will the courts allow you to pierce the corporate veil? Because they are not one and the same. That's the part you missed out.
Yeah, I think I have a legitimate reason why I would have missed that, and probably others. It's just the manner in which it was formed. We would not, I would not have addressed that with that response. Although we know that, all of us know that, the way the question was phrased, I would not have thought you were looking for that particular point.
Yeah, that's the last
But okay.
part. When you distinguish between a company and its members, it's piercing the veil. They're not one and the same. You actually have to pierce the veil if you want to get to the members. And in order to pierce the veil, you have to fall under one of the grounds, which means it has to be a mere facade.
Yeah.
Yeah. So that was the only point you were missing.
Okay, thank you. Well, that
Yes.
carried six marks. You
Of
said
course
you would
it
give
did.
me 14.
Give,
Okay.
give or take, give or take. Give or take.
Okay, good stuff, good
Right.
stuff.
All right, so you have your cases to read. I'll see if I can get to Miguel, the legislation, so you can begin to have a read through. And what else? What else did I promise you? That's it, eh?
I think, Ms. Archer, I think Miguel started to send us the documents.
He did?
Yeah. Mhm.
I'll make sure that he finishes it. And what else? And then I'll formulate a homework question for next class. I won't send it today. It'll be at the end of next class.
Okay.
Right.
So I give you time for this week to do your cases because I know everybody working, everybody is busy. So I don't want to bombard you with too much. And then everybody said they couldn't get to it. All right.
Thank you. We
Thank you,
appreciate
thank
that.
you, yes.
All right.
All right. And between all of you, someone volunteer who's gonna put all of the cases together. Like when we're finished.
We could create a Google Doc and just have it running. Everybody just add their summary to it.
Okay.
All right. I don't know how to do that, but I guess I'll find out.
Well, let them send instructions because I don't know how to do it either. But I heard it sounded nice.
Okay, I'll add everyone to it and you'll see an invitation from me and you guys can just accept it.
Oh, okay. All right. Yeah.
Very, very
Line-
good. Modern technology.
Beautiful. Yeah.
Move us to the first world, Missy.
No, that moving us into the pandemic. No, that's- all right. So
And Yvette needs the manual. Yvette, you weren't on the email communication because we received the
I do.
manual by email.
Yes, I did, but I don't
Oh.
have it in front of me and I somehow was unable to get to that screen. Because we're
Oh,
sharing
okay.
screen, I'm not able to do too much.
Oh,
Yeah,
okay.
I guess I could have, yeah.
Yeah, you could have, because that's what
Yeah, I
was
see that
doing.
now. If I just go to start and then,
Yeah, you could have
Got it.
minimized your Zoom screen.
right,
Learn
right.
every day.
Yes.
All right. So you all have a good weekend. Let's have some fun next class. Prepared. I'll see if I can find a Bahamian case. And so we could have a discussion. If I find one that's relevant, and I will circulate it.
Okay.
Wonderful.
Okay?
Yeah,
Thanks.
Thank you
Nice
so
meeting
much.
everyone.
Appreciate it.
Okay.
Same here.
All right.
Nice meeting you all.
Thank
Okay.
you.
Okay.
Good day.
All right. You're
Okay.
welcome.
Take care.
Okay, enjoy
Bye-bye.
your weekend. Bye.
Bye-bye.
Good
Bye-bye.
night,
Bye.
everyone.
Bye.
Have a good
Bye
weekend.
bye.
Hi, good
Okay.
afternoon, everyone.
Good afternoon.